I'm Ken Carlson. I have been an attorney helping tenants since 1980. I operate the caltenantlaw.com website, where you will find this and other helpful videos on your rights as a tenant. In this video, we are continuing with the trial. I'm going to get into details about doing your own jury trial, testimony, witnesses, and all the procedures. I made this video to coach you. There's a lot to do, but none of it is difficult. You just need to do it right. The landlord was hoping to be at this stage several months ago, but you had those other hearings to set up along the way. By this time, you have hopefully completed your discovery, filed your answer, and are ready to take this on. The landlord is nervous about trial because you have tripped up his expensive and incompetent lawyer all this time, and he really doesn't want to know how you are going to outsmart his lawyer at trial. He realizes that the bully thing didn't work for you, but in fact, it backfired. If the trial is without a jury, it's called a bench trial, where the judge who has been handling your case so far is probably going to be your trial judge. It may take only an hour or so, or maybe half a day. A jury trial takes much longer because of all the things required to set it up. The same judge or a different judge might handle the jury trial, but the decision will be made by the jury verdict. In your answer, you hopefully requested that require you to file a different form, UD-150, to request a jury trial, but it's enough that you put it in your answer. There is a jury fee of $150 per day that you'll need to pay unless you qualify for a fee waiver. The first day's $150, or the fee waiver, is required at least 5 days prior to the trial. In your fee waiver, you want to be sure that you request a fee waiver for the court reporter as well. Get that out of the way when you file your answer, so you won't forget to do it. If you request a jury but change your mind, you can always have a bench trial. It doesn't work in reverse, so if you didn't want a jury, but then when you saw the judge you wanted a jury, it's too late. They need to set aside a few days for the jury trial, and there are a lot of things to do in preparation for it. You will get a notice of trial from the clerk, which may include a few instructions and deadlines. The witness list identifies the people who you expect to call as witnesses, identifying how long they will take and what topics they will cover. The exhibit list is just a simplified list of what you intend to present as evidence at trial, in the order that you expect to present them, and with a number or letter to identify them, such as Exhibit 7, letter of June 15, 2026. The third item is a short statement to the jury, identifying the parties and what the case is generally about, which is to be read to the potential jurors before they are selected. The fourth item is the proposed verdict form, which can be a general one or go into specifics. The fifth item is the proposed jury instructions. Since the jury doesn't know the law, they get this crash course in the particular laws involved in your case, so they can understand the effect and importance of the evidence presented. For example, if they are told that no rent can be demanded on an illegal garage conversion, they understand that you did not fail to pay rent because the landlord could not even ask for it. There are two kinds of jury instructions. One is the standard instructions out of the book, and the other kind are special instructions that identify the law on your particular situation. Each of those 5 is required to be prepared at least a week before the trial and exchanged between you and the landlord's lawyer. Then you discuss with the landlord's lawyer to see which ones you both agree on and which ones you don't. The judge will ask about that later and resolve those disputes. At some point, the judge will need a final version of the jury instructions, which will need to be prepared for the judge to read to the jury. Usually they're prepared after the final determination is made by the judge over which instructions will be used and any changes to be made to fix those that need to fit the circumstances. You will need to make 5 sets of all of your exhibits, copied, tabbed by their exhibit number or letter, and placed into 5 3-ring binders to be distributed to the judge, the courtroom clerk, the witness on the stand, the landlord's lawyer, and yourself. That way, you can ask the witness to look at Exhibit 7, and the witness can easily flip to that page and see it for their testimony. Then, there are motions in limine, which are filed to ask the judge to order that certain things not be discussed at trial. For example, the landlord doesn't want you to mention to the jury that the landlord just got out of jail for fraud and attempted murder, because it has nothing to do with your being evicted. You can file your own. The idea is to prevent the jury from hearing evidence that doesn't help resolve the case and may turn out to be prejudicial, affecting the verdict. A jury trial brief is not required, but it may be helpful for the judge to understand where you're going with your testimony. If this is an eviction for non-payment of rent, why are you talking about the lack of permits in your home that was illegally constructed? Well, your brief explains that the illegal garage conversion prevents the landlord from demanding rent, and the judge then understands that the permits are not irrelevant to the non-payment, but go to the core of that dispute. You will want to prepare yourself in other ways as well, making an outline of what you are going to cover, working from your denials of the complaint allegations, and then each of your answers' affirmative defenses. Putting them in order helps you get organized and much more comfortable during the trial. Don't try to wing it. You will go crazy and miss important things. You want to make an opening statement to the jury about what you are going to prove. A single-spaced, single page covers about 5 minutes of talking and is enough. At the end, you will have a similar speech going over what you proved and commenting on the evidence given that the landlord should not be believed about A, B, and C because of 1, 2, and 3. You should also prepare a list of questions for yourself or each other if there are more than one of you as defendants. Sometimes a judge will just let you tell your story, but other judges want to give the landlord's lawyer the chance to object to every question to break your train of thought, confuse the jury, and make a mess of your case. A list of questions to ask the landlord and his witnesses will also be helpful after they testify. It's called cross-examination. You can add to that list as the landlord and his witnesses are testifying, so that you are asking a group of questions together on the same topic. Finally, a list of questions for the jurors to help you in your selection will be helpful. The technical name for selecting a jury is voir dire. You want to ask them questions that will help you decide which ones you want to keep and which to exclude, as well as get them ready for your presentation. That they are landlords or tenants is not the deciding factor. For example, you might ask if they could find in your favor on a technicality, even though you might otherwise owe a lot of money. Or if the landlord was evasive in answering a straightforward question or made ridiculous objections to it, would they suspect that he is just hiding his guilt? We can help you formulate those questions. Yes, it's a lot of work, but consider yourself being paid $500 per hour, which is what you will be saving by doing this yourself rather than paying a lawyer to do it. The first five items, the witness and exhibit list, statement to the jury instructions, and verdict forms, are the only ones that have to be done by a deadline. The rest you can do as the trial gets closer. The first is called a mandatory settlement conference. It's not mandatory that you settle, but that you attend. The idea is, if you can agree to settle the case without taking up 5 days of jury trial, the court saves the time, the parties save the money, and whatever is negotiated as the settlement is presumably fair. The landlord's lawyers are sneaky and might put in terms of the settlement agreement that are hidden traps. For example, the landlord might agree to let you move in 60 days in exchange for a dismissal without prejudice. You may think that means you're out in 60 days and owe nothing. Nope. It means that they cheated you out of your great defenses and then will come after you in a separate lawsuit for all the money they claim, without the great defenses that you had to the eviction case. You definitely want a lawyer's advice on settlement terms for that reason. The other meeting with the judge comes with different names like a final status conference or trial preparation conference. It's just where the judge meets with you to resolve the disputes about the 5 types of papers, especially the jury instructions. This is the first time that it will make a difference to have a recording of what is going on, electronic or by live stenographer. Generally, they only do the electronic recording, but you need to make sure that the recording is running and check from time to time. The clerks may be instructed to stop the recording when the judge is making an illegal ruling, so there is no record of it. I wish I were kidding about that, but it happens. Major decisions by the judge can be made in this first meeting that can make or break your case. Having a court reporter or an electronic recording of everything that is said can make all the difference. So, if the judge makes mistakes at this stage, you have the basis for an appeal and a reversal. Otherwise, the appeals court says that they presume the judge acted correctly and you present no proof that he did anything wrong. The law requires a correct jury instruction for each part of the case, such as your defenses. If you have an affirmative defense and a matching jury instruction that says a landlord can't ask for rent for an illegal garage conversion, the judge can't just refuse to give what you wrote. He can correct it, come up with a different one, or let you rewrite it according to his instructions. But if he refuses your jury instruction, how is the jury going to know that you had the right not to pay for an illegal apartment? They would just conclude that you didn't pay your rent for no good reason and deserve to be evicted. If the judge sabotages your case in any way, he's not about to let you win, and you need to keep track of all the things he does so that you can tell the appeals court. Again, I wish I was kidding about that, but it happens. By preventing the jury from getting instructions about your defenses, the judge is actually sabotaging your entire case, ensuring that the landlord will win even though he's wrong all the way. At this final status conference, the judge will also make rulings on the motions in limine. Some landlord lawyers, exploiting the corrupt judges, make motions in limine that, in effect, prevent you from putting on your case at all. In one case, the landlord's lawyer falsely claimed that the tenant had not given responses to the landlord's discovery, and without requiring any proof, the judge ordered that the tenants could not put on any evidence and would be punished by contempt if they even dared to suggest to the jury that they had evidence or a decent case. The recording had been stopped while the judge made that ruling, and the appeals court would not reverse the judgment because the lack of a recording meant there was no proof of the judge's misbehavior. This is real-world landlord-tenant law, folks. The judge will then set the date, time, and place to begin trial. Or any other number of modifications. Eventually, the trial will start. Negotiations can continue during this time. You can settle a case at any time. The court is just there in case you can't. If you do come to terms, you can put it in writing and the judge will sign the order to enforce it, and it's over. I mention this because the landlord has now seen that you are not scared, that you are prepared, that you have a good case, and that there's a good chance that he will spend a lot of money to lose to you, and then be sued by you for trying to evict you. He was not expecting that you would turn out to be so formidable. The more prepared you are, the more afraid he is. You're in the courtroom at the counsel table. The landlord and his lawyer always sit at the table on the side closest to the jury. The judge will have told you how many jurors you can reject, usually 6. The back door is open and you stand to face the jury coming in. They take their seats in the audience, about 40 of them. The judge welcomes them in. The judge then reads the statement to the jury, briefly explaining the case. If any of them know you, they can be excused. If they have some situation where they cannot be there, such as taking care of an invalid, they can be excused. The courtroom clerk gives you lists of names of the potential jurors, one in alphabetical order and the other by the order in which they will be called to take a seat in the jury box. You will also get a seating chart for the jury box, where you can write the names of the jurors and notes about them. If you have small post-its, when there is a replacement, these post-its fit neatly into those boxes. The judge will talk to them first, getting their name, city, occupation, and whether they have been jurors before and what kind of case it was. There may be other questions by the judge. He then lets the landlord's lawyer ask them questions. Then it's your turn to ask yours. Think of them as being just like you, except for a different face. When you finish, the judge lets you alternate in rejecting jurors. A rejection for cause is not within the limits of the jurors that you can reject, so a juror who says, "I hate all tenants," can be removed without using up one of your 6. The statement is, "I'd like to thank and excuse juror number 7. That juror goes home, and the clerk gives the next name on the list to fill that seat. Without questioning the new jurors, you go back and forth with the landlord's lawyer, removing this one and that one. The landlord can question each one of the new ones, and then you question them. Then you thank and excuse until you're satisfied with who is there, or you've used up your 6. The jury is then sworn in. The judge then gives the jury the first set of instructions about how to listen to the evidence without getting into the laws that concern your particular case. After that, the testimony starts. The general order overview is this. The landlord's lawyer presents all of his witnesses and evidence, and then finishes, and the plaintiff rests. Then it is your turn to present all of your witnesses and evidence. And when you finish, defense rests. It is the landlord's turn, then, to present evidence to challenge within the narrow scope of what you just presented. He rests again, and it's your turn to present evidence within the scope of what he just presented. When both sides have completed, the judge reads the jury instructions and sends them off to decide. They sign the verdict, which the judge reads and awards judgment according to that verdict. The presentation of a case is an art that is never mastered. You want the jury to like you, so you are pleasant, even comical, and always polite. If the landlord is a jerk, he will come off that way, and they will want to decide against him because they don't like him. You can help them reach that conclusion by the questions you ask. You want the jury to understand your case, so you need to make it as clear and simple as you can to understand the situation. Always be respectful to the judge, even if he doesn't deserve it. Don't get caught in boring and irrelevant tangents. Always be polite and don't interrupt. Stick to the story, to the points in your defenses. Make the jury familiar with the sequence of events and the reasons that things happened the way they did. Make clear who did what, why, and when. Use names, not he or she, to avoid confusion. Speak slowly enough that the jury can grasp what you mean. Use regular words rather than showing off your superior vocabulary, because if they don't understand the word, you failed the primary goal of communication. For each witness, the process is tapered, each examination by one side within the scope of the prior testimony elicited by the other. The scope means the topics that were discussed. It begins with direct examination, where the witness is first questioned by the party that invited them. After the direct is finished, the other side can ask questions within the scope of what was said, called cross-examination. If the landlord only testified that he gave you the notice, you didn't pay and he wants you out, your cross-examination is limited to that. Questions about the illegal garage conversion or uninhabitable conditions are not within that scope, so you can't raise that as cross-examination. Instead, you can testify about them when it's your turn, and then he may be forced to testify in response. For example, when he bought the place, the realtor didn't tell him that it was illegal, or that the garage had no heat. After your cross-examination, the landlord can ask questions called redirect, sticking within the scope of your cross-examination. After that, you can recross within the scope of that redirect. Unless on request of the judge to exceed the scope, which the judge permits, the testimony by a witness is tapered until there's nothing left to ask. That process is followed for each witness. There are several objections to evidence during testimony, but only a few that come up all the time. You can make these objections when the landlord's lawyer is questioning his witnesses. Lack of foundation, which only means that you have to tie your testimony to the evidence, like I took this picture in January to show the broken window. Hearsay means saying what somebody else said to prove that it was true, like a rumor. The main exception to that is when it was the landlord or one of his neighbors who said it, and it damages their case. What the building inspector told you is hearsay. You need to have the inspector testify. Personal knowledge is another objection, meaning that they question how you would know to be able to say that this is what happened. I was standing 5 feet away and saw him say X, is what they're looking for. Calls for speculation is a question asking for the witness to imagine a situation like, "Why do you think he told you that?" It's not fact. The jury can connect the dots on their own. Calls for expert opinion is that some situations require special knowledge and only an expert should be able to interpret, like, what was wrong with the electrical system? A layman could say that the electric power went off and on for no apparent reason, but an electrician could testify that the circuit breaker was a defective model. Calls for narrative is an objection to a question like, "How did the meeting go?" Better to take it through step by step. "And then what happened?" Or, "How did he respond?" Leading is when you ask your own witness a question in a form that suggests the answer, like, "Didn't you expect the repairman would come?" Better phrased, it is, "Did you expect the repairman to come?" When you are cross-examining their witness, you can ask leading questions to get to the point. "Didn't you threaten to evict me in order to stop me from requesting repairs?" Privilege is protecting the secrecy of communications in certain situations. "Did your lawyer tell you that you could get away with this?" He probably did, but the attorney-client privilege is protected communication, so they don't have to answer. When you are testifying, you have your outline in front of you on the witness stand, and your exhibits are in the order that your outline provides them. The landlord's lawyer will be objecting constantly, both in hopes of getting the judge's support in shutting out your evidence, and in hopes of breaking your concentration and train of thought to make you rattled and forget what it was that you were trying to prove. Expect that he will do that. You can tell the judge that you understand the landlord's tactic is to interrupt you so many times that the jury can't hear the truth, but that the case would proceed more smoothly if counsel will restrain himself to only legitimate objectives. The jury will get the point, and the landlord's lawyer, having been so exposed, will have to back off. When evidence is presented, there is an orderly process. I ask that Exhibit K be marked for evidence. The judge says, "So marked." And then you describe Exhibit K. "This is the letter that I got from the landlord on or about June 25, 2026. You have now laid the foundation. Then you say, "I move admission of Exhibit K." The judge asks if there are any objections, and if none, the judge says, "It is so admitted." That means it is now evidence that the jury can have with them in the jury room. You can then expound on the letter and its significance to your defense. If the judge says that the admission of exhibits will be put off until later, or if the judge will not admit the exhibit right then, you can still talk about it, even to the point of exaggeration, but not falsely. That way, the judge will see that it is better to have the exhibit be admitted than you might have made it sound even worse than it was. You can say that if the jury is not allowed to see this letter, they need to know that it is important to show that X, which is why you are trying to let them see it. Putting off a decision about exhibits being admitted until after the trial risks not getting to it at all, or undermining your strategy, so that if Exhibit K was somehow not permitted, you had Exhibit L to talk about instead. So, the patterns continue to the end. The landlord puts on their case, which is essentially what the complaint says, and they rest. Then you put on your case, which is what your answer says, and rest. The landlord then comes back with rebuttal, where he challenges what your witnesses said and the physical evidence that you presented, staying within that scope. After that, you can respond to what the landlord just said in your sur rebuttal, staying within the scope of that rebuttal. It is the same kind of back and forth that you do on a smaller scale with each witness: direct examination, cross-examination, redirect, and recross. When all evidence is in on both sides, you submit. Then it's time for closing arguments. You, the defendant, go first. It can go on for a long time, hours maybe, but you don't want to bore or wear down the jury. Stick to the facts and try not to repeat what you were telling them. You've been through a lot of information that the jury is just hearing about now for the first time. They absorb what happened with the jury instructions about the law and make sense of it. You are completing your part in this process. The process actually has a name, the Borden formula, which is tell them what you're going to tell them, and then tell them what you told them. Your closing argument is just that. Tell them what you told them. Unlike your opening speech, which was limited to what you intend to prove, your closing speech goes over the evidence, challenges credibility of the landlord's witnesses, and points out the kinds of issues that they're going to decide. For example, I showed you that after 10 years without a problem, when I asked the landlord to fix my heater, suddenly he got furious and started making wild accusations and threats of eviction. He says he wasn't retaliating, but he thought that I was a drug dealer. He had no proof of that, and I'm not. So you have to decide, which is it? What is more likely, his story or mine? Pretty easy choice, isn't it? You go over each of your defenses, what evidence you showed, how the landlord responded, the landlord's evasive responses to discovery showing that he knows he's dirty and is trying to hide it, and the plain choice, he says this, but I say that. Which is more likely? You remind them that since the landlord brought this case, he has the burden of proof. So, if it's only his word against yours, the jury has to accept your version. You can go over the ideas behind each of the main jury instructions, saying that the judge is going to tell them about X, which is going to concern A, B, and C that came out in trial. You can tell them that the verdict form will ask this question, and it means that they are deciding this set of facts. You remind them that because this is a special type of case, an unlawful detainer trying to take your home away, the technicalities can become the deciding factor. If the notice is technically wrong, if some particular thing was not done in the right way, they must decide against the landlord. You can remind them that you don't have to win on all of your defenses. Yours is the kind of case where if you win on any of your defenses, they have to decide in your favor. They may agree with all, but they only need one. You can bring on the emotion of it all. Even if they think it isn't fair to the landlord for you to win on a technicality, this is the kind of case where they are asked not about what is fair, but only whether the landlord did all of what he was required to do. He could have settled this case with you a long time ago, but he was not reasonable. He could have filed a small claims case over the money, but he chose to file this kind of case, to take your home away as the meanest kind of punishment for your exercising your rights. He chose this kind of case where the technicalities make all the difference, so that now that his case is falling apart in front of you, he can't tell you it's unfair. He did it to himself. If he had just done what you asked him, none of this would have happened. But no, he was not going to keep his customer happy. He was going to show you who's boss. So now your landlord's lawyer is going to try to ask you to feel sorry for the landlord because his finger is tired from pulling the trigger. The jury needs to tell him, with their verdict, what he wouldn't hear coming from you, that he is wrong. At your conclusion, you thank the jury for their attention, for giving up the other parts of their lives to help decide your case, and for their intelligent and thoughtful attention to the trial and in their deliberations. The landlord's lawyer gives his final speech, after which the judge will give the rest of the jury instructions about the laws they are to apply to the evidence they just heard. The jury will then go into the jury room to start to talk about your case. They will choose a foreman, sort out the exhibits, and start to talk about the case. It may be an hour or go on for days. They may ask for clarification of a fact or further instruction about the law, and the judge will work with you to provide a response to that. When they have finished, you will be notified that the jury has reached a verdict, and you return to the courtroom and stand at the counsel table. The jury comes out from the jury room and takes their seats in the jury box. The judge asks if the jury has reached a verdict, and the foreman says yes. He hands the verdict form to the bailiff, who gives it to the judge, who then reads it. They respond to each of the questions presented to them and give their final verdict. You then have the opportunity to poll the jury, where the judge asks each of them, "Was this your verdict?" It may have been 9-3 or 11-1, but the decision stands. The jury is then released and they go home. The judge will have the clerks return the original exhibits to you, which you hang on to in case there's an appeal and the case comes back to trial. The judge may have comments about the case to share with you, but at that point, the trial portion is over. Altogether, it is an exhausting process. Trial lawyers plan on a 10-hour day, even if it's only 5 hours per day actually spent in the trial. Reviewing evidence, organizing arguments, talking, rewriting questions, evaluating what was said and what needs to be said based upon what came out so far, and much more. You have to think about so many things at once and be so organized that you forget about being nervous or having stage fright, and you just lock on to the job at hand, so focused as you have never been before. You will be amazed at yourself and how you are able to handle this challenge. I've read the transcripts of my clients who did their own trials, and I burst with pride at how well they did, how well they handled the judge and the opposing lawyer. You will find the strength inside yourself to take on and succeed in this enormous task. Don't think that the jury will fail to identify with you and honor you for being so brave as to do this, standing up for yourself in a way that inspires them to be as good as you were. You can do this, and you will do this. It will be an experience you will talk about for the rest of your life, sharing it with your friends and relatives. It is a you that you never knew before and want to continue to be. It's not just a trial in this case, it's a trial of you. And you will be proud of the results. The main exception to that is when it was the landlord or one of his neighbors who said it, and it damages their case.